Hi everyone, welcome back to my channel. For today's video, we're going to be looking at Johnny's defense to Amber's counterclaim. So if you'll remember from a few videos ago, we discussed how 3 statements survived demurrer, which means that Johnny will have to defend himself against these 3 statements. All 3 of these statements are attributable to Adam Waldman. So they're not even statements that Johnny said himself. Regardless, the counterclaim was filed against Johnny Depp and not Adam Waldman, which will potentially bite Amber in the behind. Because now what she has to do is prove and convince the jury that Johnny instructed Adam to make these statements during the course of his duty. Because that's how the concept of agency works. If an agent, for example, a lawyer in this case, says something or does something outside of the scope of their employment, then agency no longer applies. Meaning, Johnny, being the principal, is no longer responsible for the actions of the agent. All right, now that I've explained that very briefly, let's look into the defense itself. So as you can see here, it starts off with Johnny's answer to Amber's counterclaim. Now, I'm pretty much going to do the same thing that I did with Amber's defense. I'm not really going to go through the answer portion because it's essentially a list of admissions and denials made by the defendant in direct relation to each and every allegation made in the counterclaim in this instance. If you want to get a better understanding of what Johnny is admitting and denying, then I suggest you open up Amber's counterclaim and Johnny's defense side by side, because every single paragraph of the defense, each numbered paragraph, corresponds directly to each numbered paragraph in the counterclaim. And also what he does not answer because it calls for a legal conclusion to be resolved in trial. An example of that is when Amber alleges that Johnny defamed her. That is a legal conclusion. You'll also notice that Johnny expressly denies all of the allegations that did not survive the demurrer stage. So even though they're not progressing to trial because they have been objected to successfully, he is still denying them expressly in his defense to cover all grounds. So when you see that he's denying them, that doesn't mean that they're going to be included in the trial. So with regards to Adam Waldman's statements, I do want to discuss how Johnny approached these statements and this defense in his answer. And this is specifically in relation to the 3 statements that survived the demurrer. As you can see here, counterclaim defendant, who is Johnny, admits that the quoted language appeared in a Daily Mail article published on April 8, 2020, and is attributed to Adam Waldman. And then he further goes on to state that as far as Amber's allegations that Mr. Waldman was Johnny's agent, Johnny expressly asserts the attorney-client privilege and work product doctrine and is not obligated to respond, and on that basis denies the same. Attorney-client privilege, I'm sure, is quite self-explanatory based on its name, and it's basically a doctrine that protects the communications that occur between an attorney and their client. They can be waived either expressly or impliedly. So, for example, if you share this communication with someone else, with a third party, then it is very arguable that the client has impliedly waived that privilege. I've also previously explained the work product doctrine. It's a doctrine that prevents the opposing side's counsel from getting access to the materials that the other side's counsel may be relying upon in anticipation of litigation. Now, this exact same answer is repeated for the 3 statements that have survived the demurrer. All right, now for the more interesting part, in my opinion, the grounds of defense that Johnny is relying upon. The first defense is, again, quite self-explanatory. The counterclaim fails to state a claim upon which relief can be granted and requests relief which is not permitted as a matter of law. So basically, Johnny's saying that she has no case. I've done nothing for her to seek compensation and to seek damages or any relief that a court can grant. The second defense is that Amber has not suffered any monetary or financial loss for which she can be compensated. Now, this one, of course, is subject to discovery. Amber has to produce documents to the other side and, of course, to the jury to prove that she has suffered any financial loss as a direct result of the 3 statements made by Adam Waldman that survived the demur. So you can see how difficult it is for her to be able to do that. The third defense is that the statements forming the basis of the counterclaim are not false and defamatory because they were truthful. It's basically Johnny relying on the defense of truth. The fourth defense is that the statements forming the basis of the counterclaim were not made by the counterclaim defendant. Now, the counterclaim defendant is Johnny. And this is what we talked about when I opened the video. Adam Waldman made these statements. So here we see Johnny's legal team basically saying that you've got the wrong guy. You're coming after the wrong person. And they do elaborate on this in the 9th defense. The 5th defense is that Johnny does not waive and specifically asserts the attorney-client privilege as to all communications between him and his attorney, Mr. Waldman. Now, I do want to remind everyone, Adam Waldman is still Johnny's attorney. Just because he is no longer directly involved in these Virginia proceedings, that doesn't mean that he's not Johnny's attorney in this particular case. He's more of a background attorney at this point. So he is still involved in this case, and the work product doctrine and client attorney privilege still apply. The defense goes on to state that if and when the court enters a final order that these communications, specifically with regards to whether Adam was Johnny's agent or whether Johnny conspired with Adam to make these statements, are not subject to attorney privilege, Johnny reserves the right to assert any and all affirmative defenses based on Johnny's lack of direction as to the subject statements, lack of direction or control of a third party as to the subject statements, a third party's exceeding of the scope of employment or agency relationship, and statements made by an independent contractor. So again, here we've alluded to this at the beginning of the video with the scope of employment. Johnny is asserting that he is relying on these defenses, which are that he didn't direct Adam to say these things, firstly. Secondly, in addition to this lack of direction, also a lack of control. And we have talked about this before, this concept of Johnny has no control over what Adam says and does, especially on his Twitter, for example. And then finally, statements made by an independent contractor, self-explanatory. He made these statements independently in his capacity as a contractor. All right, so the next 3 defenses are 3 legal doctrines, which I'm sure some of you may require an explanation on. So we have the 6th defense, which is the doctrine of unclean hands equitably bars the counterclaim. So this doctrine would bar relief to a party based on the notion that they have done something wrong in relation to this same claim. So this wrongdoing is called inequitable behavior, and it's fraud, deceit, doing things in bad faith, etc. And it's important to understand that general immorality, general wrongdoing does not cut it. So the wrongdoing or the inequitable behavior must be, as I said, directly linked to the claim that is being determined in trial. All right, now the 7th defense is the doctrine of laches. So this defense is used by defendants to claim that a plaintiff shouldn't be allowed to make a claim and bring a cause of action and seek relief because they've acted too late. There was too much delay. They should have done this sooner. So it's based on the concept of due diligence. Courts require parties to do their due diligence and not just sit around and bring claims whenever they want. They should do so in a timely manner. In fact, delay can be and is very frequently an obstacle to relief or even an obstacle to successfully bringing a claim. The eighth defense is the doctrine of equitable estoppel bars the counterclaim. So this one is a bit similar to the first doctrine, the doctrine of unclean hands. Basically, equitable estoppel would bar relief to a plaintiff who themselves have acted unfairly. And of course, again, this must be in direct relation to the claim that is being determined in litigation, not just a general unfairness. The best example I can give is if you get into a lease contract, so you lease out a shop to run a business, and the owner dupes you into signing the contract, assuring you that you are in a prime location for clientele. And let's say that this assurance is the only reason that the shop owner or the shopkeeper decided to sign the lease. So they placed faith in the words of the landlord. Now, it turns out that the landlord knew that there were going to be excavations for the light rail, which would severely disrupt business in that area. So they lied to you. They deceived you in order to get you to sign the contract. So if the shopkeeper then fails to pay rent because they weren't getting any business, they weren't generating any income, and then the landlord takes legal action against them, then the shopkeeper can rely on the doctrine of equitable estoppel to say that, well, I was duped into signing this contract to begin with. This landlord is the reason that I can't pay the rent. They lied to me and my business is suffering. The ninth defense is a failure to join a necessary or indispensable party. Now, this is where I said they elaborate more on the Adam Waldman situation in this defense. She's going after the wrong person. That's what Johnny's claiming. I'm assuming that they're claiming here that she's failed to join Adam as a co-defendant because the statements are attributable to him. And what makes this extremely important is the fact that the only statements that survive demur are all attributable to Adam Waldman. Not a single one of them was made by Johnny. So it really highlights this error that Amber committed, in my opinion, of not pursuing Adam directly for these statements. The 10th defense is that Amber is a public figure and any allegedly defamatory statements made or allegedly attributable to counterclaim defendant were not made with malice. You must have heard me say this 1,000 times by now. Actual malice is a mandatory element that must be proven when the claimant is a public figure in Virginia, not everywhere. So the rest of us, we have the negligence standard. Even if the statements were made negligently, you can stand to successfully bring a defamation claim against the person who made the statements. But in the case of public figures, it doesn't cut it. It must have been made with actual or constructive knowledge that the statements were false, or they were made with reckless disregard as to the falsity of the statement. The 11th defense is that the alleged statements that form the basis of the counterclaim are statements of opinion and protected speech. And so here Johnny is asserting the anti-SLAPP statute as Amber has in her defense. The 12th defense is that the counterclaim plaintiff Amber has failed to take reasonable steps to mitigate her alleged damages, if any. So essentially, she's failed to do her bit to soften the blow against her reputation, if any damage was actually done to her reputation. And then the 13th and final defense is that Johnny reserves the right to interpose such additional affirmative defenses as may be appropriate, including, without limitation, the matters set forth in the 5th affirmative defense above. And this is where we discussed his lack of control, lack of direction, there's no agency, it was beyond the scope, etc. And then it closes off by requesting the counterclaim be dismissed with prejudice, which means it can't be brought again in the future, and they're requesting a jury trial. So I've said this before in multiple videos, but this will all be heard in the same proceedings. There won't be separate proceedings to hear the counterclaim. It's all decided as one. As for the prospects of success, that is probably the number one question that I get, and I always have the same answer. The law is gray. I cannot predict the law. I cannot predict how things will turn out, especially now that Johnny's lost his libel case. It really highlights how you may think you have a really strong case and there's no way that you can lose this, and then the opposite happens. So I don't know. I personally think he has a very strong defense, a solid, ironclad defense. But the jury might not think the same. I also want to point out that there has been a notice put up with regards to the scheduling of jury trials. So there may be a further delay to Johnny's trial, which at this point is set for May of this year. So they want the older cases in the backlog to take priority. But we don't know whether that's going to affect Johnny's trial at this point. Other than that, that's it for this video. I hope I helped to explain things. I have been told on Twitter by a few of you that you can now read these things because of all the videos that you've watched from me. So I'm really happy that I've contributed to your understanding of legalese and how to read these things and how to comprehend these complex paragraphs that really don't have to be that complex. But are you really a lawyer if you don't use big words? I'm just joking, by the way. I was taught to be concise in law school, always. In fact, we were very heavily discouraged from showing off, throwing in big words just for the sake of it. I really hate doing that. But anyways, I'm really glad that all these months of watching my content has helped you be able to independently understand these documents. So what are your opinions? What do you think are the prospects of Johnny's defense? Do you think he has a very strong chance of successfully defending this counterclaim, or have you lost all faith in the justice system since the UK libel case? I wouldn't blame you if you said you did. If you enjoyed the video and found it informative, please don't forget to hit that thumbs up button. And if you didn't, then hit the thumbs down. If you haven't subscribed already, then please don't forget to do so you don't miss out on any future content such as this one. Thank you so much for watching. Stay safe, and I will catch you in a future video.